I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this lesson on New England state courts. This lesson is the second in our series on state courts, so if you haven't already, please view the introductory class for your respective state before moving on to this lesson. All classes can be found in our FOI guide at NEFAC.org, as well as on our YouTube channel, 5 Freedoms. In addition to state courts, we also offer lessons on state public record and open meeting laws, as well as the Federal Freedom of Information Act. Each class builds off one another, and they all collectively provide a curriculum you won't find anywhere else. Before we begin today's lesson, a special thanks to everyone who is helping us make these classes happen. SBJ New England, the Rhode Island Foundation, and the New England Society of News Editors. We appreciate everyone's support. Now, to introduce you to today's instructor, Emily Sweeney.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you all for joining us for this webinar, which is brought to you by the New England First Amendment Coalition. Now, this session is going to take a deeper dive into the courts in Vermont, and with us is Hillary Rich and Harrison Stock, and they're staff attorneys at the Vermont ACLU, and they're going to explain in greater detail how the courts work in the Green Mountain State. Harry and Hillary, thanks so much for being here.
Thanks for having us, Emily.
Thanks, great to be back.
So in this part, we're going to be discussing specific proceedings and records. Next slide, please. So on agenda for today, I'm going to first start by discussing the specific rules for accessing court hearings and what the press is allowed to record. Harry is then going to be discussing with you all the specific rules for accessing court records, whether records can be sealed and how to contest sealings. And then we're both going to discuss what you should do if you're denied access to a hearing or to a record. And there'll be also time for questions at the end. Next slide. So first, regarding the sources for courtroom rules regarding access to hearings. Now, there's no comprehensive rule or statute that governs public access to court proceedings in Vermont. Instead, we pull these rules from a couple of different sources. And one of those are the rules of procedures for specific courts. You might remember last time we talked about how there are 6 different divisions of Vermont trial courts and the Vermont Supreme Court, and each of these has their own sets of rules. Today, we're going to be focusing primarily on the civil and criminal rules of procedure. Rules also come from certain statutes. Some statutes make exceptions for specific types of proceedings. It's important to note, though, when we're talking about statutes, we are not talking about the Vermont open meeting law. That law actually includes an explicit provision that it does not apply to judicial adjudication in Vermont. And we're also pulling from the case law or the common law as sources of rules. This is when courts issue decisions that are analyzing or interpreting constitutions and statutes. And in Vermont, the courts have held that there is a general right of public access to hearings. Next slide, please. However, that right of access is broad but qualified. And that means that there is a right to access for the public and the press to court hearings, but the right does have some limits. Now, Vermont court hearings are presumptively open to the public, with closure being the exception rather than the rule. And in the criminal context specifically, the court has a certain test to analyze whether a proceeding should be open or closed. And it looks to whether the place and process have been historically open to the press and public, and if public access plays a significant positive role in the functioning of the particular process in question. Next slide, please. So although the right is broad, there are, of course, some exceptions. Some of these are found in statutes, rules, and case law. So looking first at grand jury proceedings. Although jury selection is broadly open to the public, grand jury proceedings themselves are closed by statute that actually limits who can even be in the courtroom when the grand jury proceedings are ongoing. There is also a statute that says members of the grand jury in Vermont have to take an oath promising to keep deliberation secret of the grand jury, and therefore grand jurors may not be interviewed about their deliberations. Juvenile proceedings also are an exception to this right of broad access. And in fact, the courts have said that juvenile proceedings are almost invariably closed. And this means that delinquency and dependency proceedings are typically closed to the public, There's no access to juvenile court hearings, and there are limits on the ability to even publicize a juvenile's name or image without the child or guardian's consent in juvenile proceedings. There's also a specific Vermont statute under which a person under 21 who commits a crime in Vermont can petition for something called youthful offender status. And in those cases, their case is actually transferred to the family court, which adjudicates the position on that application. And if they accept, that case actually just stays confidential. There are also protections for children in non-juvenile courts. So for example, child victims of certain sexual offenses may testify on videotape or through closed circuit systems. And even in those cases, there is a general presumption against closing the court, but the court still does have discretion. There are also a category of exceptions for when a party requests that the court be closed. And that is pulled primarily from case law, and we'll be discussing it in more detail in the next slide. So now talking about closing the courtroom upon a party's request. Like we just said, there's a broad right to access, and there's actually even a presumption of access. And to overcome that, a party seeking closure has to demonstrate that closure is essential to preserve higher values and narrowly tailored to serve that interest. Any pretrial closure order must have a clear necessity for the protection of the defendant's right to a fair trial and be limited in scope. And in criminal proceedings specifically, closure is constitutional only when it serves a compelling interest. There's a substantial probability that without closure, that interest would be harmed, and there's no alternatives to protect that interest. Next slide, please. So even if you have now overcome that first hurdle, which should be a low one, and have access to the courts, there are also the limits on what attorneys and judges might be willing to share with you outside of just the hearing itself. Attorneys are bound by their own rules of professional conduct, and one of those rules states that an attorney shall not make extrajudicial statements that they know or reasonably should know will be disseminated and have a substantial likelihood of materially prejudicing a case. Now, there are options for what an attorney can share with you, things like the claims, the defenses, general identity of the parties, typically scheduling, requests for public assistance, and if an attorney's client has been prejudiced by other statements made, they can make sometimes statements mitigating that prejudice that their client has experienced. Judges are also bound by a code of ethics called the Vermont Code of Judicial Conduct. Now, there's not a prohibition on interviewing judges, but there is a rule that a judge shall not, while a case is ongoing, make any public comment that might be reasonably expected to affect the case outcome, impair fairness, or substantially interfere with the case. However, a judge can make public statements in just the course of their official duties or explaining for public information the procedure of the court. Next slide, please. Also want to talk to you all about rights regarding recording in the courtroom. So now you've accessed the hearing and now you would like to record what's going on. And the court divides attendees into different categories or buckets, and different rights are attached depending on who you are in the courtroom. And there's different rights for participants, non-participants, and the registered media. So if you're interested in becoming registered media, you would typically apply for a registration certificate with the court administrator. There's a specific court order that says how to do this. It's a pretty straightforward form. You can apply for permanent registration or for one-time registration. Or if you don't have a permanent or one-time registration, you can apply to act temporarily. This should not be a difficult form to complete. You shouldn't receive a lot of procedural hurdles. But just as a caveat, the court has no obligation to hold up proceedings while you're getting your ducks in a row. So you'd want to get that registration certificate, in advance of actually the hearing that you want to attend. Next slide, please. So not only are there limits depending on who you are, but there's also limits depending on where you are. So looking first at rights about recording when you're in the courthouse more broadly. So this is pulled from Vermont Rules of Civil Procedure 79.2. And any person may possess and use a device in public areas non-disruptively. But participants and non-participants cannot record or transmit images or sounds of an individual outside of a courtroom without their consent. Registered media, however, have much broader recording rights. They can generally orally and visually record, although there are limits on what they can do with sequestered witnesses, confidential proceedings, the jury, except when they're seated and it's necessary. And they may visually record, but not orally record, bench conferences, conferences between co-counsel, and activity during recess. So for example, if the judge calls the attorneys up to the bench, a member of the registered media can record that discussion with just visually, but they can't audio record that confidential dialogue between the judge and the attorneys. Next slide, please. Recording in the courtroom, the rules are a little bit different, primarily for participants and non-participants. Now, no one can use a device to orally communicate or use a device with a distracting sound, so you can't take a loud phone call when you're in the courtroom, which is pretty obvious. Participants can orally record, but can't visually record or transmit. There are a few exceptions. Non-participants, when the jury is present, has to have their phones off or silent and cannot use them. But the registered media, if they have that certificate, has much broader rights, similar to what we discussed in the next slide. There are certain exceptions for like the type of interaction that they're recording, but they are permitted to orally and visually record, subject to the exceptions we discussed. There is also a limit regarding the location of the recording. The judge and the court administrator typically consult with representatives of the media to determine an area under which you can record. However, if there is an issue with multiple members of the media who all want to record at once, the court may require them to agree amongst themselves on an arrangement for pooled coverage. Go to the next slide, please. The judge themselves, though, however, may make some limitations on recording or may be interested in doing so. And if the court is considering whether to prohibit, terminate, limit recording, they first have to provide notice and they have to weigh several factors, including whether the impact of recording will have on the rights of parties to a fair trial, the nature of the testimony and the public value, the likelihood of harm to people involved in the case, the characteristics of people involved in the case, and whether the jury is sequestered or other good cause. Next slide, please. Now, even if you haven't actually been recording in the moment, it's possible that you can acquire recordings after the fact. So each docket entry should indicate whether the proceeding was video recorded, by the court itself. Those video recordings, if they were of a public proceeding, become public records, and duplicated copies may be ordered at the end of the trial or at any time by a party. Next slide, please. And for the Vermont Supreme Court specifically, they have their own rule that the news media may record their proceedings unless the Chief Justice directs otherwise, and audio recordings are available from the past 2 years of oral arguments at the website on the slide. And now I'm going to hand it over to Harry to discuss records specifically.
So you just heard about accessing particular proceedings. Now we're going to talk about how do you access particular court records. In our last presentation, you may remember that we talked generally about where to go and how to think about different types of court records, where they might be located. What we're going to do today is we're going to do a little bit of a deeper dive into particular types of records and ways of thinking about if you're seeking a particular record or you've been denied a particular record, how to think about whether or not that denial is correct or whether or not this is the type of record you might be able to get access to. And as we go about doing that, I really just want to remind everyone of kind of two background rules. The first is that for any question about court records, the ultimate authority on this is not the Vermont Public Records Act, but it's the Vermont Rules for Access to Court Records, which is a separate set of rules created by the judiciary, which govern access to court records. And so if you ever have a question about how to get particular types of court records or whether or not a denial is proper, you shouldn't look to the Public Records Act, despite the Public Records Act plain language. You should look to the Vermont Rules for Access to Court Records. The second background rule that I want to remind everyone of is a great one because of Hillary's wonderful comprehensive presentation just now, which is that the presumption for access to court records is that the public access to a court record tracks whether or not there was public access to that type of court proceeding. So the rules themselves provide that if the public has access to a proceeding and has access to a record of that proceeding. So in general, the rules for accessing records track the rules for accessing particular types of proceedings. as you're going about thinking about whether or not you can get a particular record or whether or not a record has been properly withheld, in general, you always want to engage in a two-step process. The first is to ask, under the general presumptions and rules, is what I'm seeking the kind of record that the public presumptively has access to? That is this the kind of record that anyone can ask for without giving a reason, without showing that they have a particular right of access? The second question is, regardless of what the answer to that first question was, is there an exemption or an exception to the general rules that applies to this specific document? And so we're going to look at general background rules and then specific rules. As I talked about, the types of records that you presumptively have access to track the types of proceedings you presumptively have access to. So what kinds of cases are presumptively public and generate presumptively public records? We talked about this a little bit in our last presentation. This is general civil and criminal proceedings, contested probate matters, matters originating in the environmental division, and matters to do with the Judicial Bureau. Now, despite these general proceedings which generate public records, there are many carve-outs. And the place to find the full list of carve-outs is in Rule 6B. And so if you ever have a particular question about whether a particular kind of record is one that, even if it's generated in, say, a civil proceeding to which you presumptively have access, whether this is the kind of document that you maybe don't have access to, even within that presumptively public access proceeding, you want to go to 6B. And what 6B tells you is that there are a number of types of record that, even within these presumptively public proceedings, are generally withheld from public access. These include predictably sensitive types of documents. So DNA analysis, search warrants, risk assessments, competency evaluations, juror questionnaires, and involve particular matters about juvenile proceedings. In general, these are records which you might assume have particularly heightened privacy interests. And they are records that, even if they're produced within a proceeding that's public, because they fall within this, because of the type of record they generally fall within an exception to public access. Now, you may say, okay, the record that I want was generated in a public proceeding, and it doesn't fall within anything that's listed in 6B. So can I still get the record? Or was it wrong that they withheld it? To answer that question, we have to look to the more specific rules. And there are, as I mentioned, very specific rules that, even if this is the kind of document to which you generally have access to, the particular proceedings or the particular nature of the document may mean that this specific example of it is one that you can't have access to. And the place to look for all of those rules are in the appendix to Rule 6. Appendix to Rule 6 contains a number of specific exemptions, and we would take up the full time if we were to go through all of them here. Here's a number of just kind of examples of what they look like. And as you can see, they are far more specific and tailored than the types of records which are carved out in full in Rule 6B. So as I mentioned, this is contained in something called the appendix to Rule 6 in the Vermont Rules for Public Access to Court Records. And if you're looking for a particular record, it's always good to check that appendix to see, is there any specific statute, specific rule that applies just to this type of record? Now, the good news is that the reverse is also true. So even if a record is not the kind of record to which the public presumptively have access, you still may be able to get the record. And that's because there are additional rules which say, even if not everyone can get access to this record, that is, you can't go up to the court terminal or you can't go up to a custodian and say, without giving a reason, without telling you who I am, I have access to this record. There are still particularly situated individuals or institutions that can get access to these records. And I know that a lot of folks on the call are journalists or investigators or researchers. And so the reason I want to highlight this is because even if a record is not publicly accessible, that doesn't mean that no one can get it. And there are still legal means of potentially getting access to that information. Where should you look for this? You should look for this in the appendix to Rule 5 for special access provisions. And again, here are a couple examples. Often there are examples of particular types of disclosures for research purposes or individuals who maybe submitted the information themselves. But even if a record is not publicly accessible, if you can contact or speak to someone who falls under one of these special access provisions and they are willing to share the record, that's another way that you can potentially get access to some of this information and some of this information that might find its way into the public domain. All right, I also want to talk really quickly just about sealing records. So sealing records are a way that records may start out as presumptively publicly accessible, but in the course of a case may turn out to be withheld from public view or public inspection. These are governed by Rule 9. And the way that it works is a party can request sealing, or the court can look at a record or a case document and say, you know, on the court's own motion, I think that this information is too sensitive to be made public. Any sealing request has to articulate a very specific set of demands that are listed here. This is in Rule 9A3. They have to identify the particular filing, the particular record, and the portion that they want to see, they want to withhold from public access. They have to identify the particular privacy interests that are going to be served by withholding this record. They have to state any authority that supports an order for sealing or redaction. So they have to show that it's not just they have a particular interest in this information, but there's actually some authority for withholding this type of information from the public. And they have to attach redacted and unredacted copies of the records to show the court what redaction might look like. And crucially, they have to confirm that service has been made on all parties or any other individual or entity who's the subject of the information contained in that. And the reason for this is because we want to make sure that as many people as possible know if a record is going to become sealed. If a record is going to become sealed, either because of a party's request or on the court's own motion, any person, including a non-party to the case, can request a hearing on that sealing. Any hearing on the motion has to be open to the public, except that the person can request that the court conduct some of the sensitive review of the documents in camera, which just means essentially behind closed doors, if it needs to look at the information to determine whether or not this is the type of information that should be withheld. But the moving party, that is either the court or the person requesting sealing, has the burden by clear and convincing evidence to show that this information should not be publicly released. The court has to actually go ahead and enter a finding by clear and convincing evidence that good cause and exceptional circumstances exist. And if anyone publicly objects to that sealing, the court has to essentially do another step and has to say not just that there's clear and convincing evidence on the record or in writing, but say no reasonable alternative to the sealing or redaction exists. And the manner of the redactions or the manner of the sealing is the least restrictive means possible. So it's essentially a minimization principle. There are lower burdens if both the parties say, you know what, court, we agree that this information is sensitive enough that we want to seal it and nobody objects. But the good news is that even if you weren't present for that stipulated decision, there are still opportunities to go back after the fact and unseal those records. All right, so Hillary and I have talked up to this point about the rules, about how things are supposed to work. What are ways that you can seek relief if you think that these rules aren't being followed in some way? If you think that you should have access to a record that either a custodian or a court has told you you can't get access to, or you want to attend a proceeding that you think should be public, but for one reason or another, it's closed. We're going to start with how to access the actual proceedings themselves. And I'm going to briefly turn it back over to Hillary.
Thanks, Harry. Go to the next slide. So first, talking about how do I challenge a limit on access to attending a hearing. Now, as we discussed, there is an extremely high bar for the courts to actually close the court, and prior restraint or so-called gag orders, which are limits on what can be published about a proceeding, are presumptively unconstitutional and another high bar to clear in order to be issued. But if the court has been closed or access somehow denied to the public, the media especially does have standing or the judicial right, to take action to challenge a limit to that kind of access. They can file what's called a motion to intervene or directly intervene at the trial court level. And the Vermont Supreme Court has held that once the media intervenes at the trial court level, they then are able, if they get an unsatisfactory decision, to appeal to the Supreme Court of Vermont. And there's also an option to petition for extraordinary relief with the Supreme Court directly under Vermont Rules of Appellate Procedure 21, which covers extraordinary relief in more detail. And the Supreme Court of Vermont explicitly has stated that orders limiting access should be narrowly tailored to cover only improper disclosure that would occur in the absence of the order. And in the past, these kinds of media interventions or asserting rights have been successful. In one case, a gag order was rescinded when media petitioned the court. The trial court had held that a newspaper couldn't print information that it already had in its possession. And the court ultimately reversed and held that these orders have to be narrowly tailored. And it was not done so in this case. So there is the possibility, even in these worst case scenarios, when these kinds of orders are issued, there's the potential to have that kind of decision reversed. Back to Harry.
All right, what happens if you are seeking access to a record that you've been denied and you think you should have access to it? There are actually two ways to go about getting access to a restricted record. And the route that you want to take depends a little bit on why the record has been withheld and who withheld it. So the first question you want to ask is this the kind of record that a judge has previously ruled that for whatever reason shouldn't be public? And so has there been a ruling essentially in the course of the case that means that this record is not public? If that's the case, you want to file a motion with the court in that case under Rule 9C. So what Rule 9 says is that any person, including a non-party, so this is someone who's like an intervener, like the folks that Hillary just talked about, can move to access a record not publicly accessible. You just file a motion, and the motion has to specify the case. You have to say, I want this record in this particular proceeding. And you have to say essentially why you think you're entitled to access. And the court's going to go ahead and make a ruling on that as soon as it possibly can. There's a special provision in Rule 9 that says the court has to essentially treat these requests with special speed and has to turn to them as soon as it can. If the court revisits this and says, you know what, I'm going to stand by my prior decision and we're going to keep it sealed, you have to request permission from the court to appeal that to the Supreme Court of Vermont. The reason that you have to request permission is because usually the Supreme Court only hears appeals at the end of cases. When you have a ruling that is going on in the middle of an ongoing case like this would be, you usually need special permission to take it up on interlocutory appeal. But you do have to get permission from the trial court to take that to the Supreme Court. Once it's at the if it's actually sealed at the Supreme Court level, that is, the Supreme Court is the one that has decided that this case should not be public, you file a motion under the Vermont Rule of Appellate Procedure 27, which basically just says you file this like a motion like any party in a case would. That would be a motion for extended pages, a motion to extend time. And so you should consult Vermont Rule of Appellate Procedure for the form and the format of asking the Vermont Supreme Court to unseal a record that it's already deemed should not be accessible to the public. It's important to note that this route, a motion in a case under 9C, is only appropriate where there's some discretion. That is, where the court essentially has a decision to make about whether or not a record should be withheld. In a case in which you have either statute or a clear rule that says all of these records, regardless of the privacy interests, regardless of the proceeding, are just categorically exempt, this isn't the right proceeding. In that case, you essentially want to fight with the custodian about whether or not this is the kind of record that falls within one of those rules. And that's what I'm going to talk about next. So in a case in which you have sought records, not in the course of an ongoing proceeding, essentially from the court stealing it, but you've gone to a clerk's office, you've gone to a public access terminal, and you've requested particular records and they've been denied, this is a separate procedure. And this is an appeal under Rule 6H. And because this isn't in the context of an ongoing case in which a judge is making a decision about the records, it looks a lot more like a public records request. And so if the records custodian denies you the record, either in whole or redacts part of it, they essentially have to follow the same time limits as the Public Records Act, which is typically 3 business days for a response, or if there are extraordinary circumstances, they can invoke an extension up to 10 days. If you're denied a part of that record, you have 7 days to appeal that to the presiding judge of the court in which the case was filed. We talked about this a little bit during our last presentation. That's a really important distinction, because often you can access public records from multiple courthouses or even online. But if you want to appeal the denial of a record, you have to go to the presiding judge of the court in which the case was filed. So it's really important to note sort of where the record originated. If the custodian, the clerk's office, for example, denies part of your request, they're required to tell you about the procedure for appealing, essentially how to do it in your time limits. If you take that to the presiding judge of the court in which the case is filed and you're still dissatisfied with that judge's decision about the record, then you have 30 days to appeal it to the Supreme Court of Vermont. We talked about this a little bit last week, or not last week, but in the last session. I'm just reiterating it here because it's exactly the same.
Harry and Hillary, thank you so much for giving us this great overview of the courts in Vermont, and thanks everybody for tuning in as well.
Thanks so much. Happy to be here.